Hello and welcome to the lecture. So in this lecture, we are going to start with the Polity, Citizenship and Fundamental Rights Part 2. Previously we had covered the Part 1. Now we are going to start with the Part 2. Before starting off the actual lecture, there is a small disclaimer that we are required to understand before we proceed further. And the disclaimer is like, the images, text and other materials used in our presentations are for educational purposes only. We respect the intellectual property rights of the original creators and owners. If you are the owner and have any concerns or issues, please contact us at sathi@iitk.ac.in and we shall remove the same. Now, features of fundamental rights. Article 16, subclause 3. It provides an exception by saying that Parliament may make a law prescribing a requirement of residence for job in a particular state. As Article 16 advocates the equal opportunities to everyone to be elected under the public services. But the Parliament under Article 16 subclause 3 having some power to prescribe a requirement of local residence for jobs in a particular state. People Employment Act. Previous lecture we had taken it as an example also of 1974. People Employment Act of 1974 states a person who is looking to be appointed in the public services of states of Andhra Pradesh and Telangana must require to be a local residence. Then only they could be appointed in the public services of Andhra Pradesh state government or Telangana state government. Article 16 subclause 4. Nothing in this article shall prevent the state from making any provisions for the reservation of appointments or posts in favor of any backward classes of citizens which, in the opinion of the state, is not adequately represented in the services under the state. So there are generally the four groups. The group A, then group B, group C, and group D. These groups are showing the hierarchy of jobs under the central government and then the state government. So the state, here state resembling both the central government and the state governments with the permission of central government, that they could make a reservation provisions in respect of SC, ST and OBC. Means they could select a particular SC, ST, OBC and could reserve their promotion and their appointment percentage in the group services of A, B, C, D. Powered by Article 16 subclause 4. Article 70. Abolition of untouchability. Protection of Civil Rights Act 1955 passed to give effect to this particular article. Term untouchability has not been defined anywhere in the Constitution. So far, only the Mysore High Court is the court of law which has used the term untouchability. The term untouchability is not defined anywhere in the Constitution, but Article 17 abolished the untouchability. So, the Mysore High Court in its decision described that untouchability is kind of social disability to a particular person who, because of taking a birth in certain social class, is barred to enter into the public places, go to the temples using the public utilities and all. So that's how the Article 17 disables all these practices prohibiting the individual's entry into the public places. But The term untouchability, again I'm saying, is not defined anywhere in the Constitution. The Article 70 is also available against private individuals also. Like not only the government, even the private individuals could not stop anyone to be the part of public services, public utilities, and the public places. Article 18, abolition of titles. The state means the government couldn't confer titles until it is military or academic decoration. It means the government is not allowed to give anyone's a title until or unless the title has been given for military decoration and academic achievements. Also prohibits a citizen of India from accepting titles from any foreign countries. Foreigners who hold office of profit under this government, even if they are looking to get some title from any other country, so they require the consent of Indian president before accepting it. No gift also for a foreigner without the president's approval. Even the president approval is required to enable the government officials to provide any gift to the foreign representative who has visited the country. Then comes the Article 19. Article 19 solely stands out for right to freedom. It has the sixth right within it. Article 19 is the main right, and it is having the sub 6 rights, or you can say sub 6 clauses. Right to hold property was listed by the 44th Amendment Act of 1978. So previously, before the 44th Amendment Act of 1978, the Article 19 had the 7 rights. But then one right of right to hold property was deleted, which means now it's only having the 6 rights. These rights are not applicable to aliens or the legal corporation. Here, the term aliens define the foreigners, and the legal corporation mainly defines the organizations or companies or corporations, okay, which are not a human being but a legal entity. These are not available against the private individuals. Reasonable restrictions could be imposed on the enjoyment of these rights. Restrictions should be based on the grounds mentioned in Article 19 and not on any other grounds, which means the restrictions the government could use to put on the freedom of Article 19, these restrictions are already mentioned within the article and no outer restrictions could not be applied. Now the freedom of speech and expression. Constitution imposes the reasonable restrictions on right of speech and expression when it comes to first, it includes the freedom of commercial advertisements, right against band called by a political party, freedom of silence. It does not include the right to strike. Now, what are the reasonable restrictions imposed on it? First, if the freedom of speech and expression is against the sovereignty and integrity of India, which means you are speaking something and you are expressing your views in order that you are challenging the sovereignty of the country and you are striking the integrity of the country in the negative manner, then the government could put restrictions on your Article 19 rights. Second, it is around the threat of security of the state, which means that if you are giving a speech which is actually encouraging the people to go against the state or the country, then it is liable to be the restricted area. Friendly relations with foreign state, which means that if your words, if your speech or your expression is actually damaging the India's friendly relation with the foreign countries, then the government could use the reasonable restrictions to stop you from doing that. Public order. If the speech and expression is against the public order or morality. Decency or morality, the same as I have told you in the public order. Contempt of court. If any speech and expression is against the contempt of court, then the government could put reasonable restrictions on it. Defamation. You could not use your freedom of speech and expression to defame anyone. Incitement to an offense. If you are encouraging people to do something which is considered as offense in the eyes of law, then even the reasonable restrictions could be put on your freedom under Article 19. Then the freedom of association. The freedom of association is actually a right to obtain the recognition of the association from the government. Is not a fundamental right. That means if there are three people, XYZ, they formed an association or a group called XYZ. Then formation of this particular group is actually the fundamental right. Like under Article 19, they could do it, but they could not obtain the recognition towards a association from the government. Like the fundamental right under Article 19 of freedom of association only covers the aspect that everyone is allowed to form the association, but whether the government recognize it or not, it is not covered under the freedom of association. Right to strike is not a constitutional right and can be regulated by the appropriate law. Which means any association which is formed to do a strike, that association will not be considered under the freedom of association. These will be regulated by the appropriate law, which means trade laws or industrial laws, so that the government could easily pass a provision on them without any issue. Reasonable restrictions. Interest of general public and protection of interest of any scheduled tribe. Which means if the formed association is threat to the general public interest and is actually formed to harm any scheduled tribe, then this association will not be addressed as the fundamental right and will be dissolved. Article 19 does not deal with movement outside the country. Freedom of residence is complementary to the above right. Freedom of profession is the another thing. That means the freedom of movement. It means that you could freely move inside the country of India. Okay, but there are some places like the scheduled tribe areas and the sensitive areas where the freedom to move is not applicable. You could not go there without having a proper permission from the appropriate authority. Then the freedom of residence. The freedom of residence means that an individual could be settled down anywhere within the country. But again, if there is any issue with the sensitive areas, any concerns with the scheduled tribal areas, and any issue with the general public, then the freedom of residence will not be there. Thereafter, the freedom of profession. That means the individuals are allowed to pursue any career they want to. However, the reasonable restrictions on them are: first, the government could reserve any profession as to be employed only through the government officers. Secondly, if the profession is in order that is illegal, that is against the public interest, and that is not acceptable in the terms of society, economically, or politically, then the freedom of profession will not be applicable in such a case. Article 20. Article 20 gives the protection in respect of conviction for offences. That means if there is any individual who got convicted in order that he got commits any offense, then Article 20 protects his right in such a situation. First, grants protection against arbitrary and excessive punishment to an accused person. Like in India, as you know, if there is any individual, for example, Mr. X, if Mr. X was detained or was convicted for committing an offense, then he must be given a chance to say his side. But if without giving this chance and the government take a one-sided action, which means the arbitrary action, then the Article 20 gives the protection against it. Secondly, excessive punishment. We state that the punishment must be in accordance with the convicted offense. Okay, like suppose if someone has stolen a bike, you could not grant him the capital punishment, or you can say Fasi. Okay, so that means the punishment should not be excessive and must be in accordance with the committed offense. It is applicable to almost everyone. That means both the citizen and foreigner. It covers both. So the provisions are, the first is no ex post facto law, not on civil or tax law or even on criminal trials, preventive detention cases. That means that first thing, no one will be declared convicted if he or she did not commit the crime. Or you can say that without proving that the crime has been committed by him, no one will be declared convicted or accused. Secondly, no one will get the punishment larger than the prescribed one. Okay. For example, we could take it as, suppose Mr. X. Mr. X is convicted for stealing a bike. Okay. So before the case has been proved, he will not be declared as accused. Secondly, if stealing a bike having the provision of 2 years imprisonment, then he will be sent to the jail only for 2 years, not greater than the 2 years. Okay. So that is the no ex post facto law. No one will be declared, you can say convicted or accused until or unless proving of the case. Secondly, the punishment must be given in a prescribed manner, should not be excessive in amount. And remember, this is not applicable in the civil matters or tax law, and even in the criminal trials where the preventive detention cases are there. Now, what is the preventive detention? So, detentions are generally of two types: preventive and punitive. The punitive is given in actual cases, preventive is given in potential cases. For example, you can say if there is Mr. X, he has committed something that is against the security of the country. Now he has committed this already. So if he will be detained, then that will be the punitive detention, which means it is the actual case of doing something against the country. But if he has not committed anything which is against the security of the country, but it is supposed that he could do it in the coming future, that means it is the potential case. Here, he has not did anything right now, but he having the capacity to do it in the future. So if he detained, then that will be the preventive detention. So in the prevent detention cases, no ex post facto law is not applicable. No double jeopardy, which means no one will be punished for same offense more than once. Okay. It is not available in the proceedings before the departmental or administrative authorities. That means in the departmental or administrative authorities, a person could be punished for the same crime again and again, but in the legal authorities or half of quasi judicial authorities, it is prescribed that no one will be punished for the same offense more than once. If Mr. X was already punished under IPC section 32, for example only, and if again he committed a crime, then again he will not be liable to be punished under the same section 32 of IPC. He will get new sections or new punishment. No self-incrimination, which means the accused is not allowed to accept that he has done the crime. So no self-incrimination is prohibited, but it is only available in the criminal cases. Like if there is Mr. X and he said that he has done something criminal with Mr. Y and he accepted this fact in before of court. Even then the court will not accept the fact and order the proper investigation to find out whether in reality Mr. X committed the crime or not. But this is only available in the matters of criminal cases, and when the matter is the civil proceeding, this provision is not applicable. Now what is Article 21? Article 21 provides the protection of life and personal liberty. It means the procedure established by law. That actually puts the restriction over the government's power to get anyone's life and anyone's personal liberty. It means the government could act accordingly the law that has been established as per the procedure established by the Constitution. It means no law which has been passed by the government should be in order that it is actually posing a threat towards the life and personal liberty of the individuals. In the Gopalan case, it was not available against the arbitrary legislative action. That means the government could make the laws like this, but these laws could not be implemented by the executive organs of the government. Menka Gandhi case, the wide interpretation of Article 21, and they said that if the law provisions are just, fair and reasonable, then only they will be considered as not against the provisions of Article 21. But if they having any unjust, unfair and unreasonable thing, then they will be declared null and void because they are against the provisions of Article 21. Various rights including under this are: first, right to live with human dignity, right to decent environment including the pollution-free water and air, and protection against the hazardous industries, right to livelihood, right to privacy, right to shelter, right to health, right to free education up to 14 years of age. That is also known as elementary education. Okay. Remember, right to free education up to 14 years of age was previously mentioned in the liberal directive principles of state policy. So what do you mean by the DPSP? We will let them know. We will got to know about them in the upcoming parts. Till then, just remember, previously This particular provision of right to free education up to 14 years of age was presented in the liberal directive principle of the state policy. Later on, through the 86th Amendment Act of 2002, that was became the fundamental right and established a new article within the Article 21, that is known as Article 21 subsection A, which means that it is the responsibility of the government to provide the elementary education up to the children who has not attained the 14 years of age. Right to free legal aid, that is also covered under Article 39A, which is also presented in the Socialist Directive Principles of State Policy. Right against the solitary confinement. Right to a speedy trial. Right to travel abroad. Right against the bonded labor. Right against custodial harassment. Right to a fair trial by the judicial authority. Right of prisoners to have necessities of life. Right of women to be treated with decency and dignity. Right against public hanging. Right to information, that is also give effect by the RTI Act of 2005. It means that if the individual wants to know about the activities of government bodies, then he could use his RTI powers. He could apply it with the Central Information Commission, which was established in the year of 2005 through the RTI Act. Okay. And then the Central Information Commission will become liable to provide the adequate and appropriate information to the information seeker. Right to reputation, it means everyone having a right against the defamation and having a right to live with the proper reputation. Right to privacy, it means the government having no right to hurt the privacy of an individual. However, if it is done for the intelligence, surveillance, then the right to privacy is not covered under Article 21. Then comes the Article 21A, right to education. Free and compulsory education to all children in the age group of 6 to 14 years, that is also known as elementary education. And this article was added through 86 Constitutional Amendment Act of 2002. Here you can say it also. 86 Constitutional Amendment Act 2002. Then comes the Article 22. It gives the protection against arrest and detention. The types of detention are punitive and preventive. The punitive is in the actual case and the preventive is in the potential case. First part of Article 22. Right to be informed of the grounds of arrest. It means if the authorities arrest anyone, then the person who got arrested by the authorities having the fundamental right that he must be informed why he got arrested, or we could say on which grounds he got arrested. Right to consult and be defended by a legal practitioner. The arrested person or detained person having the right that he could consult it with the legal practitioner and could also ask the legal practitioner to help him. Right to be produced before a magistrate within 24 hours. Now, if Mr. X, he got arrested by the police force on 12 a.m. 12th January, then before 12 a.m. 13th January, he must be produced before the magistrate. It means within the time frame of 24 hours, the magistrate must be there to hear his appeal and hear the point of police force. And if the magistrate further confirmed that Mr. X should be in the police custody, then only the police force or approved authority could hold him. But once the magistrate is not confirmed that this person should be in the custody, then the police force has to release him immediately. Right to be released after 24 hours unless the magistrate authorizes the further detention, as I have told you. These are applicable to those acts which are of criminal or quasi-criminal nature. It is not generally available in the civil or administrative matter to produce the detained one in front of the magistrate. If the offense is of the criminal nature or quasi-criminal nature, then only he or she is required to be produced before the magistrate within the 24 hours. These safeguards are not available to a person who detained under the preventive detention law and also to an alien. That means only in the punitive detention, the person could use the provisions of first part of Article 22. But if he got arrested because of the preventive, means he having the potential to do something of criminal nature or threatful nature against the government, against the state or against the people of the country, then he will be detained under the preventive detention law, and so thus these provisions will not be available for him. Even if the person is alien or foreigner, then these rights will not be applicable on him freely. Preventive detention provisions are applicable to both citizens as well as aliens, which means authorities on doubt could detain the citizens of the country as well as any foreigner who has visited the country. Detention of a person couldn't exceed 3 months unless an advisory board recommends the same. The board is to consist of judges of High Court. Like, suppose if Mr. X was detained on 1st January under the provisions of preventive detention, then the authorities could not detain him as long as they want to. He could only be detained till completion of 3 months. That means till 31st March only. And once the tenure of 31st March is over, the person, means Mr. X, should be released until or unless the detention board or the advisory board, which consists the judges of High Court, they suggest that Mr. X should be detained for a long, or they are satisfied that the grounds on detention for Mr. X are in accordance with the proper law and the conditions were there. Then only he could be detained for a long. Ground of detention should be communicated to the detainee. However, the facts considered important may not be communicated, which means that even if someone who got detained under the preventive detention, he must be communicated that why he got detained. But the facts that are important facts, okay, because of the security reasons or whatever you can say important reasons, these facts may or may not be communicated to the person who got detained. Opportunity for representation should be provided, like the detainee person having the right that he could also got an opportunity to say his side, to get the help of legality, and to get him outside this situation. Constitution has divided the legislative powers with regard to the preventive detention between the Parliament, exclusive for defence, foreign affairs and security of India, and the state legislature. The rest matters are under the state governments. Then the Article 23. Article 23 prohibits the trafficking in human beings and forced labor. Like we know, in the historical times, many countries, even India, having the practicing of forced labor. That means the kind of you can say bandhuwa mazduri, in which generally the money lenders, the zamindars, and all they signed a bond with the weak peoples, and then according to the bond, the weak people are required to work for them on the low wages or even without the wages. That is the forced labor. And trafficking of human beings, like kidnapping the human being and transferred it for various kind of illegal things. These things are prohibited by the Article 23. Protection against the private actions as well. It means it is not only available against the public authorities, but even the private individuals is not allowed to do a human trafficking and having the forced labors. Compulsion arising from economic reasons are also including. Exception, compulsory military service. It means the government could ask the youngsters to serve the certain years in the military, and that will be not count as the forced labor because that is for the national security concerns. Article 24 prohibits the employment of children in factories. Does not prohibit the employment in harmless activities. That means the employment of children who below the age of 14 years or below the age of 18 years is only prohibits in the hazardous or dangerous works. It does not prohibit it in the harmless activities. Commission for Protection of Child Rights Act 2005 was enacted to provide for the National Commission and the State Commission for Child Rights. Then the right to freedom of religion covers under Article 25 to Article 28. Article 25. Freedom of conscience and free profession, practice and propagation of religion. No forcible conversion allowed. Available to both citizens and non-citizens. Covers both rituals and practices. It guarantees the right of individuals. The state could regulate these religious institutions as well. The state could provide for social welfare and reforms to these institutions. Article 26 provides freedom to manage the religious affairs. First, to establish the institutions. It means any religious denomination is having the right that they could establish the religious institution to provide the religious teachings. Even they could manage their own religious affairs. They could own the property. And they could even manage or administer the such property. It guarantees the rights of religious. These are not subject to other provisions relating to the fundamental rights. Now, what is the religious denomination? It is a group of people who having the common religious beliefs. They form the common organization. and their organization must having the distinct name to specify that whether it is the religious denomination or just another social group. Article 27 provides the freedom of taxation for promotion of a religion. It means that the government could not levy of taxes on the people for pursuing their religions. Okay, but remember, the government could not levy a tax but could charge a fee against the government services in the religious nature. For example, suppose if you had visited the shrine of Vaishno Devi in J&K, okay, so you have to pay rupees 50, for example, as the entry fee. Now, this rupee 50 is not a tax that the government is collecting from you because you are pursuing your religion. It is actually the entry fee the government is charging against its services being provided you to keep yourself safe and making your traveling easy. Article 28 provides the freedom from attending the religious instructions. The institution wholly set up by use of state funds could not provide the religious instructions. The prohibited from the religious instructions prohibition services. The institution administered by a state but established by a trust, they could allowed up to some extent to provide the religious instructions. Institutions recognized by the state, they could even provide the religious instructions but only on the voluntary basis. Institution receiving the aid from a state, they could also provide the religious instructions but only on voluntary basis. Cultural and educational rights under Article 29 to 30. Article 29. Right to conserve the distinct language, script or culture of its own. No discrimination could be made on the basis of language in educational institutions. This is applicable to not just to minorities. It provides protection to both religious and linguistic minorities. Then, Article 30. To administer the educational institutions. Applicable to both religious and linguistic minorities. Here, the protection is confined only to the minorities and not covers the majorities of the society. Article 32 provides the right to constitutional remedies. It is the most important part of the fundamental rights. It means if there is any individual who feels that his or her fundamental rights have been deprived of, then they could move to the court for the enforcement of their right. And it is also the fundamental right in itself. The parliament could empower any court to issue the directions, orders, and writs of all kind in order to enforce the fundamental rights. Generally, Article 32 gives right to move to the Supreme Court in case of deprivation of fundamental rights. The President could suspend the enforcement of fundamental rights during the national emergency, Article 359. Sorry, 352. Just correct it. That is 352. Under Article 352. Okay. So, Article 32 is not applicable whenever the national emergency of Article 352 is applicable in the country. Remember, only Article 20 and Article 21. Only these two articles are there which are even applicable during the case of national emergency. Like if the rights promised under Article 20 and 21 get deprived of, then the person could use Article 32. Otherwise, they could not use the Article 32 whenever the national emergency is imposed. And remember, during the Article 34 stands out for military or martial law. During that article, okay, During that particular military or martial law, the Article 20 and Article 24, even they both get cancelled. Article 32 could be invoked in only those cases where there is a violation of fundamental rights. Writs. Before 1950, only the high courts of Bombay, Madras, and Kolkata could issue the writs. And these were the three presidencies of Britishers: Bombay, Madras, and Kolkata. And the idea of writs is borrowed from the Britishers. Writ jurisdiction of Supreme Court is narrower than the High Court, which means the Supreme Court could only issue the writs in the case of fundamental rights, whereas the High Court could issue them in the case of fundamental rights, in the case of legal rights, and in the case of any law which is essential in nature. So it means the High Court could issue the writs on the wider matters in comparison with the Supreme Court. Territorial jurisdiction of Supreme Court is much greater than the High Court. High Court could only issue the writ in the matter of their territorial jurisdiction, whereas the Supreme Court could issue the writs for all over the country. Supreme Court is actually the defender and guarantor of the fundamental rights. So that's why the Article 32 gives the provision that any individual in the case of deprivation of fundamental rights directly move to the Supreme Court. First writ is habeas corpus. It is the tool of individual liberty against the arbitrary detention. Can be issued against both the public and private individuals. The writ couldn't be issued in the following cases. First, if the person is detained on the lawful grounds. Second, if the person got detained because of the proceedings against the contempt of legislature or court, then the habeas corpus will not applicable. Detention is by a competent of court. Detention is outside the court jurisdiction. In such a cases, the habeas corpus is not applicable. Then the mandamus. It is demanding a public official to perform a duty which he has failed to perform. It could be issued against an inferior court also. It couldn't be issued against the private individual body to enforce the departmental instruction that does not possess the statutory force. When the duty is discretionary, to enforce a contractual obligation against the president or governor, against the CGI or a judge of high court acting in judicial capacity. Now the prohibition. It means to forbid. Issued by a higher court to a lower court to prevent the exceeding jurisdiction. It is only against the judicial and quasi-judicial bodies. It is not available against the administrative authorities, legislative bodies, and private individuals or bodies. Then the certiorari. It is much like a verb, but it is curative as well. It is available against the administrative authorities as well. Quo warranto. It is to adjudicate the legality of a claim of a person to public office. It could be issued against the public offices of substantive character. Couldn't be issued against the ministerial or private office. Any instated person could seek the application of this. Then the armed forces and the fundamental rights. Article 33 gives Parliament the authority to limit or abolish the basic rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and similar entities under the government. Objective behind this article is to ensure the proper discharge of their duties and maintenance of discipline amongst them. Power to make laws under this is conferred only to the Parliament, and the state legislatures are not allowed to use the Article 33 to make the provisions. Martial law and fundamental rights. Article 34 imposes the limits on fundamental rights, while the martial law is in effect in any portion of the India's jurisdiction. Parliament has the authority to reimburse any government official for restoring peace and order, while the martial law is in effect. even if such acts violated the fundamental rights. The concept of martial law has been borrowed from the Britishers. Despite its mention, the term martial law has not been defined anywhere in the Constitution. There are no justification given for the establishment of martial law. During the period of martial law, the military officials have extraordinary authority to conduct any required actions. However, the Supreme Court held habeas corpus is not suspended when the martial law is in force. Now, the Supreme Court could ask the authority to release any individual if he or she is detained on the unlawful grounds. Article 35. Effecting the certain fundamental rights. In the following sections, the Parliament shall have the rights and the state legislature shall not have the power to pass the legislation. Prescribing residence is a condition for certain employments or appointments in a union territory or a local authority or other authority. Allows courts other than the Supreme Court and High Courts to issue the various directives, orders and writs. Restriction or abolition of the applicability of basic rights to members of the armed services, police forces and so forth. Indemnifying any government or any other person for any act done during the operation of martial law in any area. Punishment for acts involving the untouchability. Trafficking in human beings and forced labor. Article 31A. Saving of laws providing for acquisition of estates, etc. It protects the 5 types of legislation from being challenged and annulled on the basis of violations of Article 14 and 19. The state acquires states and associated rights. Taking over the management of properties by the state. Amalgamation of corporations. Extinguishment or modification of corporate directors or shareholders' right. Extinguishment or modification of mining leases. Article 31B. Validation of certain acts and regulations. It protects the acts and regulations in the 9th schedule from being challenged and annulled for violating any of the fundamental rights. The Supreme Court concluded in one of its decisions that there could be no blanket immunity. Laws adopted after the Keshavananda Bharati decision could be challenged in the court if they infringe the fundamental rights provided by Article 14, 15, 19 and 21. Then the Article 31C. Saving of laws giving effect to certain directive principles. It contains the following 2 provisions. No legislation shall be declared unlawful if it strives to give effect to Articles 39B or 39C, even if it breaches Article 14 or 19. Courts are barred from challenging such legislation so that such a policy is not implemented. This clause was deemed illegal by the court in the Keshavananda Bharati judgment. Here we have finished this lecture. Thank you.